I guess. But I don't like just boring nothing on.
Yeah. That and sports, Bears and socks, I'll always wear.
Man, I as much as I love the Bears, I struggle because I don't like their colors. I don't like the orange color. Like I don't know, it's just not a color.
Orange is like the alternate. Like orange didn't exist 15 years ago. It was always navy and gold.
Oh man, all of my Bear stuff is either navy blue and white, or I have some black and white. But all right, man, we're live, man. Welcome everybody to Chicago Landlord Secrets, a show that we're doing live every week. But you can catch the repeat, or you catch the recording on either Facebook, LinkedIn, or YouTube. So check it out. Thanks for joining us here today. I'm excited to be with my co-host Tim, the one and only, the madman Southside property manager. Tim, how are we doing?
Doing good. I got the text, the full first draft of the pro. So
wow, tell me a little bit. One, how'd you get that access, and then two, tell us kind of what we're up against there, or maybe give a recap of what we're looking at.
So I got a notice or something like, or whatever you want to call it, that it actually was released. And then after spending a lot of time trying to find it, I realized I'm not smart enough. But I realized that I have someone smarter than me on my team named Claude. So I went to Claude and I told him to find it.
Nice.
He found me the entire article. So PRO is the Protecting Renters Ordinance that was released by Mayor Johnson's team. He's doing a whole press tour on it. It's probably his last attempt, although he was in an interview that I saw last week saying he hasn't talked to his wife on if he can run for re-election yet or not.
I saw that yesterday in a press conference. I saw him say something like that.
So I'm not sure now. I don't know. I'm thinking this is his last grasp for even having a shot of being reelected and trying to get renters. But now I don't even know, because now his wife might not let him run. So
well, he's taking a lot of heat now. Also, I was watching stuff, just everything with the shootings on Juneteenth and him going against. He vetoed that the curfew law. So the city council put something out there to allow police the rights to, if they see an urgent matter like that over 4th of July, they could put an immediate curfew into place. And he vetoed that, the ability to do that, which obviously put a lot of people in danger. A whole bunch of people got shot. Like a whole bunch of crazy stuff happened there on the 4th of July weekend. So I don't know. He's fallen out of favor even more so, even from some of his own people and his own voters from the first round. So we'll see how that goes. I'm hoping that just takes the steam out of this bill that we're talking about.
Yeah, especially when you see it as when you see that, like, I don't know, like, so we had Tinley Park has like a whole 4th of July weekend thing and a big event, and there was an attempted teen takeover there, and it was basically smothered down. And they weren't allowed access and booted out. So when you see other towns, I know Chicago's much bigger, but like there is things that you can do and allow the police to do that would help, and it's shown to work in other villages. And like you said, he vetoed it. Like, it was passed by city council to set this curfew up, and he vetoed it. So,
and first thing, it was amazing. First, I think it was 14 years. First thing that was, I wanted to look up what was the last thing that was vetoed, but his first thing in city council has been vetoed in 14 years by a mayor.
That's crazy. That's crazy. But anyway, so I think that the highlights that we've heard about, right, have been this just eviction, the ban on fees, the annual fee and registration, and the new Bureau of Renters' Rights or something like that. People, right? Is there one more? Is that the four that like has sort of been the headline?
That's it. The other one is the parental fee. Yeah, you combine them all together.
Yeah. Cool. So that's been there. So I went through the last hour, 49 pages of very small writing, with a lot of cross-outs and a lot of weird things to try to put together some things that, some clarity that we've all been looking for, and then B, some things that are interesting that I found in there that I don't think anyone's talking about. So we'll go through them like we did the bill deck and go one by one and sort of get your feedback on these.
Yeah, let's do it. Love it.
All right. So there's actually there's an entire like 2-page section on the beginning that actually has tenants requirements. So rules that the tenants have to follow, which I found interesting, but a lot of it has to do with complying to the municipal code, throwing away your garbage and trash cans, keeping the place clean, keeping all plumbing fixtures in the dwelling clean, using in a reasonable manner electric, plumbing, sanitary, heating, and ventilating and stuff, not deliberately destroying things in the apartment, and not conducting themselves in a way that would require another person to lose their right to peaceful enjoyment of the premise. So there is some interesting that they carved that out, because I don't think the current RLTO has anything that like specifically says like, hey, tenants, if you do this, you're in violation of the RLTO. So first page is actually a surprise for me, that they had a little bit for the landlord. But then after that, there's an entire like 2-page section on it about allowing your landlord access that I found very I mean, I think most of it's the same rules, right? It's 48 hours, 48 hours to get access unless it's an emergency. But there's actually a landlord can fine a tenant if they're not allowing the landlord entry, if they're actually physically blocking the landlord from entering or preventing them. The landlord can fine up to $100 per day.
Oh, wow.
For that.
And that's not in, sometimes we lose sight of what's actually in the current one. There's nothing about any consequence if they don't allow us access right now, you're saying?
I don't think so. I mean, not that
I've never heard of it.
I didn't have time to like cross-reference and double check but I've never heard of it. I've never seen it. And I feel like one of us would have, right?
Yeah.
If it existed, if we were able to charge a tenant $100 a day when they don't let us in, because how often you get that tenant? Hopefully not that often, but it exists, and we see it where you get the tenant that puts in their rent's late. They put in the complaint because you're about to evict them, and then you go fix it, and they go, no, you can't come in. My dog's here, and you can't come in. But it's not fixed, so I'm going to go to court and try to tell the judge that you didn't fix it.
Yeah, and sometimes it's the dog they weren't supposed to have either.
Yeah,
but that's great. That is actually something that would be positive. So
that's the positive there. There are a few interesting rules or provisions on the entry part. One is showing to tenants, showing new prospective tenants the apartment. They actually capped that to 60 days out. So you cannot show prospective tenants the apartment more than 60 days out, which we don't do pre-showings at all, really, because it just our apartments aren't very, very good for it. But I know you guys do a little bit. Are you ever more than that, or?
No, we're never more than that. We usually get the ball rolling about 60 days to have it on the market by 45 days. And it's strictly, for the most part, a Northwest side thing. We do it somewhat in the suburbs from time to time, but I feel the expectation to view a leased apartment or occupied apartment as a future applicant is a lot more normal in the city than it is in the suburb.
Yep. So 60 days. It is interesting. They actually crossed out the original writing that they crossed out said you had to give 2 days notice. It was changed to 48 hours. So I have a feeling that there's going to be some attorney that's going to start trying to fight or sue landlords based on like, well, you served notice at 8 a.m. for a 7:45 entry. But it's specifically, they're very, very specific about it being 48 hours. Also, this law has a reasonable entry time, meaning that even when you give 48 hours, it has to be between 8 a.m. and 8 p.m. Unless the tenant requested a different time. And then like I said, the interesting part: any tenant that violates this section is subject to a fine not less than 50 and not more than 100 each day. A violation persists shall constitute a separate and distinct offense. So that means $100 a day. And even, however, though, there is if a landlord violates it and you enter for a non-emergency or non-unforeseen maintenance issue, the fine is $250 to $750 that they can go after you in court for.
Man, I wonder how they. I mean, to be reversed against, they'd have to call an attorney and kind of get that in a court. Like that'd be hard to enforce, but it's also a real threat.
Yeah, I mean, I'm sure there's some. I mean, we've seen those attorneys that started going after security deposits when it became harder. I'm sure there's someone that's going to try to make a living off of. Has your landlord enter your apartment and you only give 47 hours notice? Let's go get you $150.
Yeah,
and I'm going to keep 600 of it, but you'll make 100. Speaking of attorneys, new language on all notices, all 5-day notices, 10-day notices, 30-day notices. You must write the following statement on the notice. You may wish to contact a lawyer or your local legal aid or housing counseling agency to discuss any rights you may have. So you have to remind them that they can hire a lawyer now if this passes. Notice. Okay, so this is the right now in Chicago. Just to remind everyone, if you're going to increase rent, we have a very complicated system of if they have been there less than a year, you must give, or less than 6 months, you must give 30 days notice. Between that 6 month to 3 years, it's 60-day notice. And then if it's over 3 years, it's 120-day notice. This law would now change any rent increase to a 120-day notice and any renewal that doesn't include a rent increase to a 90-day notice. And that, I'm not just to not jump ahead. The reason that 90-day renewal without an increase seems interesting because I was like, who really? I mean, I guess who's renewing without an increase? But it comes into play with the way that you're going to be able to non-renew someone or get them out of the property without having to pay a lot of money for relocation fees. So them denying a renewal offer is one of the few ways that you can not have to pay relocation. But we'll get into that in a second. Fee restrictions. Tell me if you're over or under on these right now. Application fee capped at $20 or actual cost, whatever's lower.
We're over. We're at 65 right now.
Yeah.
But the national law that comes into play the state law, it will limit at 50.
Right. So it's going to go from 50. So we'll have 50 for well, it won't ever be 50 because the start date of this law, if it passes, is supposed to be January 1st. So Chicago will be limited to $20. You can only charge a one-time pet fee or recurring monthly pet fee, but not both.
So you could, okay, I got you.
So you can't have a pet fee and you can't have a pet move-in fee and a pet monthly fee, is what it's saying. And it has to you have to somehow prove that the fee is reasonable cost of like what the damage a dog normally does, normal wear and tear, which I don't know how that's going to be calculated. So that'll be interesting.
Do you do both right now? Do you charge?
We only have the monthly. So, I mean, obviously the first month is included in the first month's rent. So, a fee for non-mandatory. So these are the fees that we can charge. And anything that's not listed, basically, you're not going to be allowed to charge for. But the highlights here and they're sort of limited. The move-in fee, basically, like you have to be able to show that it's actual expenses. So if you made copies of keys, etc., you have to show the actual expenses to do a move-in fee, which I think Cook County in Illinois is already going to be doing. So I think it's not. I don't necessarily agree with it, but I think we already have to abide by that by the new Illinois law. So, and then a fee for optional services, such as I know we do. We have like filters and things like that we deliver to our tenants. So you are allowed to charge that, but it cannot exceed the actual cost for the service. And then utilities. Again, you can charge a tenant for utilities, but you have to provide them now. You're going to have to provide them a copy of the bills, and you cannot charge anything extra, including for internet, gas, water, any of those. There cannot be any add-on charges for your charges.
Yeah, so that puts everyone at jeopardy of the rent's $1,500 plus $50 for the gas bill every month. It has to be actual charges.
Yep, exactly.
Actual rubs.
Mark's favorite word. This one is actually, it makes sense. Or I guess it makes sense to me that as a landlord, I don't not necessarily like it, but I get it. If you've searched for property management recently, I think that versus 6-7 years ago, I think most of us have raised our discretionary amount that we can fix something without having to go and get owner's permission. Well, Chicago has also done that now, or will be doing that if this passes. So right now the RLTO says that if a landlord doesn't fix something in 14 days, a tenant can pay someone to fix it up to $500. That is going to move up to $1,500.
Have you ever had that happen? I've not ever had that happen.
No, but I've had a lot of tenants tell me they're withholding. Like this was the number one training that I had to give my rent collection team that really helped them, because you get a lot of tenants that tell you they're going to withhold rent. And the correct response to that, and obviously the correct response is fix it, but there's sometimes where you get these tenants, which I'm actually really glad about this law preventing. We're dealing with a tenant now like this, where a tenant is withholding rent, but also not allowing us to do the work. So it's like, okay, well, you can withhold the rent, but you have to spend that money to fix the problem. And
to hold the rent, they're actually required to set it aside and be able to have proof that they have that money set aside and have not spent it on a car payment or on a weekend trip or whatever. Like they have to actually have it allocated towards an expense sitting there. So is there any further requirements? They don't have to have it in a bank account or anything.
They don't have to have it in a bank. They just have to be able to show they have it. But for this one, it's 14 days. They can actually withhold rent up to a month, up to a half month's rent, or $1,500, whatever's larger, and then they can do the repair up to $1,500 and provide receipts.
Is there any restriction on how long the landlord has to actually get it fixed?
14 days.
14 days. Okay.
Yep. So.
Yeah, that's most that ends up being that just ends up being an overall non-issue for the most part. I imagine you agree. Like, most landlords are going to fix stuff that needs to be fixed, and the ones that are playing that I don't want to say game, but playing using that rule as leverage of holding money back usually have some other tenancy issue, whether it be they're being evicted, they have a large balance, they can't fulfill the lease, or you're busting their chops about the 2 dogs they shouldn't have in there, and they're not wanting to get rid of them, so now they start playing this game. So I mean, it's if you're a good as long as you're keeping up on your maintenance, it's usually not a real problem that ends up being more of a tenant problem.
Yep. No, I agree. I mean, I honestly have no issue with that law. I think it is something that, like, there are some things as a landlord and as a property manager that are fair, right? Like, we can't have everything lean to us, because that would be bad for tenants.
Yeah.
And that's one that I think that we both agree that, like, hey, if you're a landlord, you should be taking care of the property, and you shouldn't be slumming around. And that's yeah, I think that's a big thing, and I think that's why you'll see property managers say, like, hey, we need to have the right to be able to fix this, because I guarantee you that my plumber is going to fix the problem for $200 that they're going to call ABC Plumbing. And I don't know if you've ever dealt with them at all or have anyone. ABC Plumbing will charge you $2,000 to unclog a toilet. They're going to call the most advertised local place, because they don't know any better, and get and probably the worst rate in general. So
I think a lot of people, where the value comes from people that work with companies like yours or mine, is, yes, you'll send that $200 plumber, and even if it's $300, but if he messes up, he maybe doesn't do the full job, or maybe he has to get called back out because maybe the issue is a little bigger than what we originally thought, he's coming right back out. like to get him back out. He has so much, you're probably giving that plumber X amount of thousands of work on an annual basis, where it's in his best interest to get back there ASAP and service that and fix that problem, versus if you had to call ABC Plumbing, they might take a couple of days. They're going to send a different guy out this time, even and you might just run into overall issue. And then you're trying to get customer service to help you fix things. Like, I think being able to control the outcomes of having that type of network within maintenance is huge. It's a huge value that our clients do get.
Yep. No, I agree. All right, you ready for a game?
Yep.
All right, this is the part that I think we've all been we've heard rumors and we've seen it, but we didn't know where it would end up. So I'm going to give you 3 options for all these. 1 is you can do it for free. 2 is you have to pay 5 months of rent or $5,000, whatever's higher. And number 3 is 10 months of rent or $10,000.
Okay.
as
0, 5, or 10
as your options of to kick a tenant out. What will happen? What do you need?
All right. So per this law, you're going to give us the hypothetical situations, and I'm going to guess how much it's going to cost for me to solve that problem or get that tenant out. All right. I love it. Let's play.
Right. Hopefully we're going to start with an easy one. Non-payment of rent.
Non-payment of rent, that should fall under 0, but hypothetically, you're losing a lot of money either way. So, but you shouldn't have to pay him anything to leave, right? Yeah.
Correct. Right. You are losing money still, but yes, but you do not.
It's still costing you.
Yeah. You're not worried about that. Okay. Occupancy by owner or qualified relative.
I'm going to say $5,000.
Yep, that is correct.
Wow. How about that? To move back into your own house, you have to write a check.
Now, there's a caveat to that. If you don't move back in within 3 months, or if you don't stay for 12 continuous months, you can get sued or no more.
Wow. So then now it puts the investigation work into the tenant to come and see if you're actually living there 9 months later.
Yeah. Yep.
Wow. All right. What else?
Condo conversion. I'm not going to try to say the whole word.
So condominium conversion. So they're basically they're converting. So you're kicking them out. I'm going to say 0.
That one is another 5.
5. Okay. I thought I heard that was 0 and I was shocked by that. All right. So $5,000. Okay.
So I remember hearing that too.
Is it $5,000 or 5 months? Is it the minimum, the least of the two, or?
It's the higher of the two.
Wow. So $5,000 or 5 months. So if you have a $2,000 condo and they're coming out, you have to, now that makes the cost of the the person buying the condo complex to convert to apartments that much higher, because you're going to have to pay each individual owner $10,000 more to account for the money they have to turn around and pay that tenant. Now, the good thing about condo conversions, a lot of times the people converting it to apartments will be happy to keep the tenant if they're anywhere close to market rate. Yeah,
but it could also be the other way too, though, right? You have a 3-unit building and you're trying to make them into 3 condos.
Yeah.
And then sell them. So
so that, I guess that would be.
Yeah.
So the rule is written either way: condos to apartments or apartments to condos. Gotcha.
Yep. All right. Here's another one that we were really worried about or didn't know was going to happen, but refusal to renew rental agreement. Whether it's because of a price increase, I'll say. $5,000 or 5 months. So this is the change. It is actually 0 that we someone got through to them.
Give a scenario. Give me a scenario that this would apply.
You say, I want your rent is going to go up $100 a month, and the tenant says, no, I don't want to pay that extra 100. So raising the rent, which was something that we were watching, because the initial thought was that they were going to say, if you raise the rent $100 and the tenant says no, that you would have to pay that 5 months, but it's actually showing as 0.
Oh man. Okay.
So we won that. There is a caveat,
because that was the scariest one of all of them.
It is. There is a caveat though.
Okay.
If the tenant can prove that the landlord is increasing the rent to bait them into denying renewal, then they can get then they would have to pay the 10 months.
Give an example.
So I have a 3-unit building, and the top floor I increased the rent $50. The second floor I increased the rent $50, and the first floor I increased the rent $700. because I want that tenant to leave.
Gotcha. So it basically inflating it.
Yeah, inflating. Yeah, you have to prove that you're treating all tenants equal, that you're not raising. So if you own 3 buildings, and this is why I think having a management company again, I think this law, unfortunately, is going to be, it's going to make using a management, fortunately for us, but unfortunately for the general public, it's going to make using a management company in Chicago almost a necessity, because there's so many little caveats and so many little I's that you have to dot now. If you can't show that, hey, look, I am across the board raising rent 5% on all my tenants, because that's the market increase right now, they can go after you for those 10 months and try to prove that, hey, you increased their rent more than the other tenants.
Gotcha.
So, unreasonable denial of a landlord's access to a dwelling unit, which we sort of talked about already, that the fines exist.
I'm going to say 0.
Yep. It's also another, it's a get out of jail free card.
So if you have a Section 8 tenant that you need to do repairs on in order to pass inspection, they're not giving you access, you could ultimately not renew them and tell them, obviously that's a different set of problems of getting them out, but you can at least not get in trouble for it, or not have to write a check for it at that point.
So there's a problem with that theory, and I'll skip to this one as the next one. Failing a CHA inspection and going into abatement.
Oh my gosh. So that's even written in there, huh?
Yep.
Wow. I'll tell you this, man. Every time we've ever been in abatement, short of a couple times where it's like, we just missed that last thing on that long list, and now it's the third inspection. It has always been it's either the tenant has been difficult and got us to that point, or it's been like a pest issue that we attempt to solve and we're not getting access, and the tenant's not helping on their end. So, man, that is a tough one, because I'll tell you this, man, the abatement 9.5 out of 10 times is typically not our fault, and usually dealing with someone unruly or unhappy, and now we have to make a business decision if we want to even work with that person. So that sucks. So is that going to be a 5 months then?
That is a 5 month. Yep. Significant repairs actually falls under two. There's significant repairs needed that fall under 2 things. One is to comply with court, a city violation, or a voucher abatement, or 2, you want to rehabilitate or make necessary repairs to the dwelling unit, which would, according to a licensed contractor, render the unit uninhabitable during rehab or repair. So if a contractor says that, hey, while I do these repairs, it wouldn't be smart to have them there, you can then pay 5 months to have them out. Demoing a unit. This one's interesting, so I'm surprised it's in here, but if you wanted to demo and knock down an entire unit.
I imagine that's going to be a 10-month one.
No, that one's 5.
Really? I thought they would go harder on that one, just because they're so discouraging of tearing down buildings, similar around the 606, that they're going to try to take you for everything.
I would agree. That one I was a little surprised. Material non-compliance, we sort of talked about already, but if you deliberately or recklessly violating the lease, or making it threaten health, safety, or peaceful enjoyment by committing crime in the unit, or serious breach of material terms of the rental agreement, that one's free.
Wow. And so that surprised me too, because I don't know if we talked about it here yet, but they're redoing the whole, out here in the suburbs, we have the crime-free program. They're actually redoing that because people are getting displaced because they called 911 for their own safety, or they're getting displaced for a different reason. So that kind of goes in the opposite direction of where, I don't know, mainstream, or where kind of that law that's been around for 25 years is going.
Yep. Any other reason? Number 8 is just if you're not listed, if you're non-renewing them for any other reason, that is going to be your 10-month.
Just any other reason, huh?
Any other reason. If it's not in there, it's any other reason.
That's your catch-all. Like, all right, if we let anything slip through here. So
yeah.
Ah, man, that's all. That's just all painful, and it makes you revisit the whole idea of investing in Chicago. So I am totally hopeful that nothing even close to this passes anytime in our next 20 years of existence here in the city.
It's interesting.
Now the RTL can use some updating. There are some good things that you just broke down that could be positive additions, but I almost feel like they're not going to update this agreement, which hasn't been updated since I think it got updated again in the early 2000s. But that was very small updates from its originality in '86. So I feel like they're going to, in order to actually make the amendment and change everything, they're going to have to do something drastic, which is probably not going to fly in the benefit of the landlord.
Yeah, it's going to be interesting. I'm probably going to give this another read through and see if there's anything else I missed for next week. The only other one that caught my eye as very interesting is they have a whole thing on security deposit laws, which we know is a big part of the RLTO. The new addendum to it though is just saying now that you just have to give the tenant all the interest. So any interest earned by that tenant's security deposit is property of that tenant.
Yeah, that sort of makes sense, I guess.
It does. That one, it makes sense. Like
security deposit is never technically yours. It's just literally
right. So I think that one makes actually, like I said, some of it makes sense. It's a tenant protection or whatever, but it makes sense. I personally, the fact that the city of Chicago, we can't get our new leases written until like January 2nd every year because
they don't put that damn.
We don't know. But they literally think about it for like 12 months and they go, you know what? For the last 15 years, you know what? 0.001%. like, and it has no correlate because interest, as we all know, has gone from 0 to like 10 at one point and then back down to 7 and 6. Like we've had probably the most volatile interest rates in the last 5 years ever. And yet the RLTO is just like, no, 0.01.
This past year, we didn't even mess around with waiting. We just put it in 0.01 and we said, if we're wrong, then we'll go back and fix it. But man, we probably got an 80% chance that we will bet right here and we won't sit around. And, I remember years past, and we try to get all the lease we can sign before the end of the year where it just falls under that. But it's like the 3 or 4 that come in that first week of the month in January, it's like, oh man, just wait 2 more days. And we got to modify the template.
Yeah. So here's what I'm reading in terms of what's next. At this point, they presented it on June 29th. They are open for people coming to them and talking to them, et cetera, which I know the MBOA's got people. Chicago Association of Realtors have a lot of pull that they're trying to use. And then obviously all of these renters organizations are in the ears of all these aldermen trying to get updates. So they will listen to everyone for a few months and then they will vote on this in the fall. So we're probably not going to hear anything until September, October.
The last I heard though, there wasn't as many renter organizations involved as there's been in other topics in the past. So
that's good.
I've heard that it's been limited to some of the Southwest Hispanic neighborhoods that have been the ones that have been supported on the resident side. And some of these other groups that have been around in Edgewater, Andersonville, like that way, have not jumped in on this. Now, that's no reason to not take this seriously, but I do think that some of these residents see how this is going to hurt them. I think there's a level of education that's out there this round, or there's been time. I wrote an article the other day of just the 5 reasons this is going to hurt the tenants, and I think people are seeing that far sooner, because I think there's a level of distrust in government right now where it's like, what you're putting out there right now is that, I know it's got this beautiful wrapper on it that says you're going to help me, but is this really going to help me? So if anything,
you're adding fees. I mean, someone put it out there, right? Like when you think about it, being a landlord is a business, right? Like just like tariffs, right? That was a big thing that we talked about in January and February, and the whole country, every news you put on, tariff. Well, no, the foreign country's going to pay it. No, that's not how that works.
Yeah.
Like it comes here, it is paid, and then the price of that product increases by that amount. The whole fee, we're looking at a $40 to $60 fee annually for every unit. That's just going to be added on to the tenant's rent.
Well, because a lot of people don't realize, majority, and I don't know, I'm not I don't have the exact number, but I imagine if you broke down debt versus equity for owners, investors across the entire city, these properties are leveraged. There's debt service on them. There's all the taxes that you see. There's the garbage dumpsters. There's all these expenses that, at the end of the day, most landlords are not making more than 5 or 10% return on their investment, which is very little cash flow. Now, there's other benefits to being an owner and writing off taxes, and the property goes up in value. The tenants are paying down the note, but there's usually not much meat on the bones for landlords. And you have two choices: make a heck of a lot less money, or try to find a way to work that into your cost of delivering your rent. So it will. This big bad landlord theory, it just isn't as big bad realistic here in Chicago, and this is going to hurt, because there's a lot of good landlords out there that want to do the right thing, and some of the guys will not pass these things on, and they will hurt, or they will sell because they can't make any money, and
or you end up like New York, right, where there's so many rules and so many restrictions on funds that now you literally have buildings. It was just in the news last week. You have buildings falling down. And why is that? Because these landlords they haven't been able to increase rent in 10 years, and they can't afford to fix the brick facade on the building, and now it's falling apart.
All right, you got a question here. What's the biggest change you've seen in the Chicago rental market this year, Tim?
Biggest change?
I'll go if you want a second.
Yeah, go ahead. Yeah, give me a second to think about it.
So I think this has been a change that's been creeping up over the last couple of years, but the difference in what you get for rent for an updated unit, maybe white cabinets, plank floor, versus a not updated unit, maybe it's a hardwood that has been refinished in a decade, and older cabinets. And even the funny thing is, these just wood oak cabinets, they're brand new 20 years ago, but now they're old. So it used to be a $25 or $50 a month difference, and now it's turning into $150 to $250, or maybe 3 to 5% of the overall rent. And also, you're getting the units rented a lot faster than you are the non-occupied or non-updated unit. So putting that money back into your account, or into your property, is going to actually put money back into your account. So that's been what I've seen.
No, I think that's a huge one. The other thing I'll throw in, now that I had time to think about it, is the subsidies there's just the amount of, like 2 years ago, to find a subsidy tenant, especially, we're on the south side and things like that. So we focus on that a lot. You would get it rented in a week, and it would take forever to get the process done, but at least the tenant finding was easy. Right now, the way that they're being so strict on the vouchers and releasing them and giving them out, there's a lot of families that we've dealt with that, they had a 3-bedroom voucher, now they have a 2 or a 1-bedroom voucher. So just that the subsidy tenants, I don't want to say there's not as many of them, but they don't have as many bedrooms. They don't have the buying power that they had a few years ago. So that's been a huge change over the last year or so.
Do you know how many people or how long the waiting list is for
the waiting list isn't even worth. The waiting list is something like 2 million or something like that.
No way! Come on, that many people?
Something ridiculous. I'm probably exaggerating a little bit, but it's 10 to 20 years.
Wow.
So by the time you get called, I went on it. I signed up when I was 20. So they opened it up. They only open it up like every 5 or 6 years. So I still haven't got my call.
All right. You got are you seeing more investor interest in the Southside neighborhoods lately, or is that cooled off?
I think it's actually getting hotter in specific neighborhoods. And I think the thing with Chicago, right, when you say north side, south side, I think that Chicago's, unlike a lot of cities, is 2 block by block. So I think that there are some neighborhoods. I think South Shore, for instance, right, we saw the last 3 or 4 years that it was all hype and everyone was buying there, and now that's cooled off. Now that the Obama library is finally done and everything's sort of settling, maybe it'll pick up again. But Woodlawn the stuff selling in Woodlawn right now is crazy. Just the amount of money that they're going for and that we're seeing things sell for and things like that. So there's areas that we're seeing huge increases in. I think even there's areas like that weren't ever a topic, such as like what is it called? I call it ABC land. I'm trying to think of the actual name of the area up there close to Indiana.
The Alphabet Street.
Yeah,
So it's just the east side.
East side. Okay, east side. But there's another name for it, but we'll call it east side. Even over there you've been seeing more and more people start to go that way and invest.
You got the east side and Hegwish.
Hegwish. That's actually what I'm looking for. Hegwish. Yeah. Gotcha. You've actually seen a big. I just read an article that was really interesting. They're seeing a big LGBTQ movement from like Lakeview and stuff like that out to Hegwish. So really? you're seeing different areas that are picking up that were never. I mean, I can't even think of the name of it because it's not a neighborhood that's on the top of tongue very often. But you're seeing it pick up and more people buy out there.
What I find so interesting is Hegwish is, if you look at it on a map, is basically an island. Like the neighborhood's totally, it's cut off by everything on all four sides. So I always find that very interesting. And the east side, man, we never really talk about the east side on our podcast or on here, but there's so much opportunity on the east side. And the Alphabet Streets, Avenue M, Avenue L, and there's actually reasonable prices. It's a whole crazy Hispanic community down there that, not crazy Hispanic, but it's a crazy cool neighborhood, mostly Hispanic that has been, I still think some of the properties are undervalued there as well too. So
yeah, and you have the things you need, right? You have a metro right there. If you're towards like 86 and commercial, right there, there's
you got the Lake line, yeah.
There's a lot of. I'm starting to see restaurants. I'm in the area a lot. We manage a lot of properties over there. So as you're walking through, you start to see restaurants and things like that weren't there 3 or 4 years ago start to get built. And just the more that starts to happen, the more appreciation you're going to start to see.
Yeah, it's actually a pretty little vibrant. If you look at 106 in commercial down there, our colleague Jared Cott, Marblestone is right there. But it's a pretty little vibrant community right there, little with this commercial fronts and so forth. So I do love that east side part. So what else you got before we wrap here?
Nothing offhand. That's been my trying to find this thing. This writing was so hidden that I honestly was trying to Google and trying to get through the city pages and couldn't, and gave up and went to Claude. I was telling you that before we went live, but like it's that they're not making it easy to get to, but we got the text and went through it. And I think that's been the big thing on my mind. But how about you?
Coming up, so an episode that came out on Straight Up Chicago Investor today is pretty interesting. It's Tom bought a property from a wholesaler that it was a fraudulent sale, and he got a loan on it. It was like a 1.5 million from Renovo, and it walks through the whole story of the year it took him to get that settled back and get his money back. He didn't get much for his time or anything like that, but it's a great story. And then next week we have the Cook County Assessor Pat Hines, or the incoming one, on the show as well too. So we got a couple of great episodes that we'll probably bring some of those talking points back here. But check those out. And if anyone has any questions on property management, or you have a landlord situation, you don't have to hire us. Just call us up. We'll help you through it. If you need any resources, you need a guy for this, or you need a roof, like we got guys. Always happy to help and share with the Chicago real estate community. If you have questions on a specific neighborhood, or you have a property you're looking at, run it by as well too. You can reach us both, either through the chats of these saved episodes, or you can find us on LinkedIn or Instagram. But thanks, Tim, as always. And listeners, make sure you share this, and we'll see you next week.
Later, guys.
Hey,